May I permitted to mention two intercourt appeal, which I mentioned last week, and you'll also please to direct them to appear on Friday. And council matter will come from outside, my lord.
But this Friday there is some difficulty.
Yes, but CBI matter also directed, CBI matter also directed to appear, my lord. So what can I do, my lord?
This Friday and the next Friday there is some personal difficulty for me. Probably 22nd.
Yes, well, I shall call to Mr.
You
Percy.
just confirm
Yes,
and
my lord.
place.
Yes, yes, deep love.
May I pray Justice Chatterjee's leave to mention one matter before the Honorable Chief Justice. My lord, taking that matter, my lord, the heart matter, sitting with Justice Bhattacharya, my lord.
Yes,
My lord,
review application stays there.
Stays there, but difficulties. Our most learned senior advocate, Mr. Mukherjee, Shaktinath Mukherjee, is leading us. My lord
The
knows this.
problem is, Justice Hiranmay Bhattacharya's determination is very heavy. We have got about, how many matters will be there? 15 to 20 matters. Huh?
My lord, I have the order, my lord. I have the order. Few matters relating to the heart has been tagged.
No. That has to be heard because there are a lot of advocates on either side appearing.
Yes, my lord, I have informed on behalf of the petitioners.
Give the letter, let us see when I will discuss with Justice Bhattacharya and then.
Grateful, my lord. Grateful.
With your lordship's kind leave, I'd like to mention a couple of matters. They were taken up yesterday, my lord. They are items 12 and 13 of the monthly list, but I was indisposed and I couldn't attend the hearing.
What did we do? We didn't.
My lord, it was a not today, but in the case status report, it shows that it's reappearing in November. So I'd be very grateful if the matter.
It in September probably.
My lord, I'd be very grateful if the matter could be returned in
the to November.
E-courts case status the E-courts. 3rd November is showing in the E-court status. That's why I've come today.
You just verify.
I'll,
it was not even called as what the court of
Lordship, I had sought for an adjournment on his.
And we said September, not in November.
Yes, but E-courts is showing as
We will verify.
I'd be very grateful if it can be kept this month.
Okay, we'll try.
Oh, my lord, the matter in Atherton engineering, my lord, we've applied for a certified copy. The problem is the JA number is mentioned as 2 of 24. It should be 1 of 24. And my learned friend's name has not appeared.
Okay, we will show it in days list and make the correction.
Wait.
Original side daily list item number 1 for hearing.
Your Lordship, with item number 1, Your Lordship, this is our application. Your Lordship, this matter has come up today. All of a sudden, Your Lordship, Your Lordship, I may be granted. Yes, Your Lordship.
You are wrong. It was Lordship. There in the warning list and in the monthly list. Now you are not ready. That's it.
Lordship, I have missed it, Your Lordship, somehow.
Wait.
Lordship, yes, Your Lordship.
Please wait. Mode of publication of appointment of St. Joseph. Where is the order of the tribunal? Yes. And who will appear for the respondent?
Lordship, on the last occasion when the matter was called up in the year 24 also, Your Lordship, no one appeared for the respondent, Your Lordship. Lordship, on similar issues, appeal SLPs are pending, Your Lordship, but I need to take instructions whether they have been decided or not, Your Lordship.
But last occasion, we wanted a clarification to be obtained. And what have you done on that?
Yes, Your Lordship. The clarification regarding the matter was whether it can be heard or not, and the matters are pending, Your Lordship. Regarding that only, I need some time. Kindly grant me 1 week's time, Your Lordship. I'll get back with the instructions, Your Lordship.
The Central Excise Act.
Yes.
But the tribunal can keep it aspect. Now, in your grounds, where is she? She's gone. Huh?
No, Your Lordship, I'm there.
In your grounds, you have relied upon one decision of the Sestat Delhi, Bhushan Limited. Have you filed
Yes.
the copy of the decision here in the paper book? See, whether the question is whether the tribunal can examine this aspect.
Yes, Your Lordship.
That is the issue.
Your Lordship, this Bhushan, Your Lordship.
Have you got that decision? In fact, you have raised that in your grounds.
Yes, Your Lordship. Your Lordship, kindly grant me some time, Your Lordship, since today I am in a bit difficulty, Your Lordship. The paper book is also is not available with me, Your Lordship. I have the soft copy, Your Lordship, but
After this order was passed, you have forgotten about the matter. Last it came on 2023.
Yes,
we have
yes,
heard
Your
so
Lordship.
learned advocate appearing for the appellant. None appears for the respondent. Despite the direction issued on 3rd May 2023, till date the department has not given appropriate instructions to the learned advocate appearing for the department. If instruction is not given within a week, the court may be inclined to dismiss the appeal list after a week.
Item number 2.
Yes, means who specially assigned. The appeal was not admitted, but direction for paper book was given. Who appeared on see the order sheet?
Your Lordship, the appeal was admitted on 31st 3 2010, Your Lordship.
There is an interim order also. Or we will put it next week because paper book is filed. We shouldn't dismiss. None appears for the appellant. So and so appears for the respondent. List after 2 weeks. Because Kaushik Dey is now in the panel, he can't appear.
Lordship, in last year, in 2023 also, no one has appeared for the appellant in this matter, Your Lordship.
Yeah. None appears for the appellant. So and so appears for the respondent. As could be seen from the order sheet, even on earlier occasion, none appeared for appellant. Thus it appears that the appellant is not interested in prosecuting the matter. Appeal dismissed for non-prosecution. The substantial question of law admitted for consideration is left open.
Number 3.
Obliged.
My lord, Mr. Harish Chakraborty appearing in this matter.
Hmm.
It is very old matter, my lord. I am praying for 1 week time, my lord.
Lordship, Mr. Kundalya appears for the department.
All right. At the request of the learned advocates on either side, September.
Grateful, my lord.
Item number 4.
You give the order sheet to me. Okay. Somendu Banerjee. Who is Somendu Banerjee? He has appeared. But this is assessee appeal. And there is some interim order also. Interim order was granted. Sir, you give the paper book. Two volumes, huh? Four. Huh? Oof. You dismiss it very. But I think probably they have not noted it. Hmm. All right, so one chance we'll give. None appears for the appellant. So and so appears for the respondent. List in the monthly list of September.
Obliged, Your Lordship.
Item number 5.
if your lordship kindly takes up this matter any other day, my lord.
No,
today-
no, Mr. Bhattacharjee, 180 days delay in filing the appeal.
My lord,
Finding of the tribunal prima facie is perverse.
my lord,
How many appeals the revenue files with enormous amount of delay?
my lord,
He has given us some explanation.
my lord,
He has lost one forum. We will set aside the order, condone the delay, the rest appeal to the tribunal to be heard and decided on merits.
my lord, my lord, my lord, my lord.
This appeal filed under section 35 capital G of the Central Excise Act 1944 is directed against the order dated 29th April 2008 passed by the Customs, Excise and Service Tax Appellate Tribunal, Eastern Regional Bench, Kolkata, within bracket Tribunal, in miscellaneous application number 289 of 2007, stay petition number 417 of 2007, and excise appeal number 430 of 2007. The appeal was admitted on 10th of August 2011 on the following substantial questions of law. Please extract two questions. None appears for the appellant. We have heard Mr. Uday Shankar Bhattacharjee, learned senior standing counsel, appearing for the appellant, assisted by Aishwarya Rajshri, learned standing counsel, appearing for the not appellant, respondent.
Respondent, my lord, respondent.
Department. The appellant assessee filed the appeal before the tribunal, challenging the order in appeal, order hyphen in appeal, number 65/KOL-Roman 3/06, dated 31/8/2006, passed by the Commissioner within bracket appeal, Roman 1 bracket close, Central Excise, Kolkata. Order. Page 42. The said appeal was filed by the appellant assessee, challenging the order in original number 2/demand/05, dated 25/7/2005, passed by the Assistant Commissioner, Central Excise, Dum Dum, Roman 2 Division, Kolkata, Roman 3 Commissioner, confirming the demand of rupees 3,27,507 under section 11 capital A of the Act of this Act, imposing a equivalent amount of penalty in terms of the provisions of section 11 capital A capital C, and charging interest at appropriate rate under section 11 capital A capital B. The appellate authority by order dated 31/8/2006 dismissed the appeal. Agreed by such order, the assessee filed appeal before the learned tribunal. The appeal before the learned tribunal was not filed within the period of limitation, but there was a delay of 180 days in filing the appeal. An explanation was offered by the assessee stating that the order passed by the appellate authority was received by a dealing assistant who did not bring it to the notice of the management, and the dealing assistant left the organization in December 2006, and the person who was subsequently appointed had traced out the order and the appeal was filed. The department did not file any affidavit in opposition before the learned tribunal, objecting to the reasons given by the assessee for not able to prefer the appeal within the period of limitation. However, before the learned tribunal, the department representative opposed the prayer for continuation of delay and stated that the reasons given are baseless, and if it is accepted by the learned tribunal, it will cause irreparable injury to the revenue. At this juncture, we can take judicial notice of the fact that seldom the department files their appeal within the period of limitation before this court. And many a times, this court has exercised discretion and condoned the delay, as this court, while considering the appeal, was required to consider as to whether any substantial question of law arises for consideration. That apart, the delay of 180 days cannot be stated to be inordinate, nor the appellant assessee can be stated to have been not diligent in prosecuting the matter. The appellant had contested the show cause notice issued by the Assistant Commissioner of Central Excise submitted written submissions before the adjudicating authority. And had attended a personal hearing which was granted on 18/8/2004, cannot be stated to have been not diligent to prosecute, to put forth their submissions before the adjudicating authority. The adjudicating authority, having held against the appellant assessee by passing order in original dated 25/7/2005, the appellant immediately preferred appeal before the Commissioner Appeals. Contesting the order adjudication order on merits. However, the appeal was dismissed by the appellate authority, against which the assessee preferred appeal before the tribunal. The learned tribunal, being the last fact-finding authority in the hierarchy of authorities as provided under the provisions of the Central Excise Act 1944, the remedy before the learned tribunal is not only an efficacious remedy but an effective remedy. This is more so because if the assessee is aggrieved by the order passed by the tribunal and prefers an appeal before this court under section 35(G) of the Act, the court can consider the appeal only if a substantial question of law arises for consideration. Therefore, we are of the view that the appellant should be granted an opportunity to contest the matter on merits and to merits, so as to enable the learned tribunal to take a decision on merits after considering the submissions of the appellant assessee. For the above reasons, the appeal is allowed. The impugned order passed by the learned tribunal is set aside, and the matter stands, and the appeal stands set aside, and the delay in filing the appeal is condoned, and the appeal is directed to be restored to the file of the learned tribunal to be heard and decided on merits and in accordance with law. Upon the appeal being restored, the registry of the learned tribunal shall serve notice on the appellant, assessee as well as the department, and thereafter proceed to fix a date for hearing of the matter.
My lord, tribunal also give us hearing also, my lord, is directly only appellant, my lord. Parties should be given the hearing, my lord.
Notice to both of you, appellant and department.
My lord.
Notice to both of you. Notice and hearing.
My lord.
Consequently, the substantial questions of law are left open.
Grateful, my lord.
Next.
For admission of tax matters, item number 6. 6 and 7.
7 is
6 and 7.
Lord, had taken up 7 yesterday. So we were into the
Yes,
decisions.
IT 36.
Yes.
Lord, we were into the decisions.
Actually, the original authority, assessing officer, merely referred to Totgar's cooperative say and rejected your claim. The same was the decision by the CIT appeals
CIT appeal
and the tribunal.
And AO had, before AO had given the entire facts. That these are the funds received from NABARD, a government government owned entity, for distribution to the agriculturists. So we received in 2 tranches, and that was distributed as per requirement over the year. So in the interregnum period, we were putting it into the fixed deposits, and therefrom we were getting the interest. So, my lord, I had referred to serial number 1, which is a decision by my lords, and this is pertaining to 263. But the proposition has been very clearly accepted that in case of cooperative society like this, if surplus fund has been invested, then it will qualify for deduction under 8AP. 10th line from the bottom at page number 2.
No, before the tribunal, did you canvass the point that this amount which was deposited in the bank was not an amount due to the members? It is the amount which was received from NABARD and partly distributed to the members, and the remaining was kept in deposit. That ground was raised.
That is there. Firstly, the assessment order, clearly my submissions have been noted down by the AO. Lord, we can revisit assessment order at page 48. My submissions have been recorded at page 52.
52.
Page 52.
Yes.
My lord, this fact was again reiterated before the Honorable Tribunal by way of written submissions. My written submission is at page 99.
This Vasavamba Cooperative Society also followed Totagars.
And my lord, putting entire thing into perspective, my lord, in my lord's order has referred to that amount due to the members. If that is deployed, then I am not entitled to the benefit under 80P. If some amount is due to the members. My lord, my lord has referred to Karnataka High Court decision, Uti Gay Derera Credit Society at page 2, my lord.
Yes.
Last 10 lines. So that decision I have also enclosed, wherein they have referred to Todgar
And distinguished it.
What are the facts, my lord, in Todgar? It was a mixed cooperative. They were selling the produce of the members
Agricultural
and
produce.
retaining that money, and that money was deposited in the bank account. So that was the amount due to the members. So when I am retaining the money of the members, that is not in the business attributable to the business of providing credit facilities to the members. So now in Karnataka High Court decision and even Telangana High Court, they have also interpreted the word attributable to, which is distinguishable from derived to. Derived from.
Where is Karnataka?
Look, Karnataka at page 6, at page 8. At page 8, my lord, the language at para 8, the language of the statute has been reproduced.
The whole of the amount of profits and gains of the business attributable to any one or more of such activities.
So my activity is
Carrying on
under
banking
I.
business.
Clause I. Carrying on business of banking. I'm not carrying on business of banking. I am carrying on the business of providing credit
facility
to the members. So anything attributable to this business will qualify for 80P deduction. And there they have not used the word derived from. So if derived is there, then strictly whatever interest I am receiving from member, that is qualifying. But over and above that, anything else will not qualify. But
So two components you are investing. One is when NABARD releases the funds, you will have to distribute it to the member societies. But if suppose something is remaining in surplus, still it is distributed, that is kept in deposit. Then the other component is when you distribute the credit to the members, they repay in installments.
my lord,
And those installment amounts are retained. And once in a half year, you will have to remit it to NABARD. Until that period, you hold on to that money. So it is all attributable to
the
providing.
I could not have placed it better, madam. Exactly, this is my case. And Todgar has been dealt with at page 9, para 11.
Page 9, para
11.
11. It was also in the business of marketing of agriculture produce grown by its members. So it is members' money.
Members.
And what is the other decision? Tumkur.
Again from Karnataka High Court, my lord. This decision at page 13 reiterates the same position of law. Page 13, para 9 and 10. Again, Todgar has been distinguished.
So there they get the agriculture produce, sell, retain the money. Invest it, get interest. Then it is payable to the members. So therefore you are not entitled to ATP.
And even Telangana High Court has also dealt with.
Telangana.
And again, they have also referred to Todgar. Telangana is at page 14, my lord. Page 17, para 12 and 13. They have discussed the meaning of attributable to, significance of the term attributable to. And finally, at page 22, para 34, 35, 36, 37. Para 34, Todgar has been referred to.
My lord, only one submission. If your lordship will kindly see the tribunal's order, my lord, your lordship has seen that podcast. Paragraph 6, my lord, page 3. My lord, I'm straight away coming to lordship, page number 4. My lord, from my lord, 6th line from top. The principal source of loan was received from NABARD. Your lordship got NABARD, which is in turn distributed to the individuals who are in fact members of the primary such and such. The assessing officer categorized the income under the category eligible income, being the interest or individual derived from the investments of any other cooperative society or the ineligible income. In the course of assessment, the breakup of the various clubbed various incomes clubs under the various heads was examined. Now, my lord, I am placing note. It was noticed that the assessee had not segregated the eligible income from certain other incomes arising out of his other activities, which is no direct nexus to the principal.
That is the question.
Yes, yes.
Now, whether it has a direct nexus with the principal activity.
Yeah.
There is no other activity. Rogas you cannot rely upon.
The assessing officer noticed that the claim of deductions made in respect of the higher proportion to its income was eligible under the law. The assessing officer noticed that the assessee has credited amount of rupees 18 and such towards the interest received from the receivable, out of which the amount of rupees 384.60 had received, and receivable with an amount of rupees 384 has been earned with the bank deposits. But this is not the observation was not only this portion, and thereafter, my lord, He has relied
All
the
findings of
broadcast.
the AO and CIT.
Yes, but AO's finding, if your lordship will kindly see. AO assessment order starts at page number 48. The finding in this respect is, if your lordship will kindly see, page number 50. They have discussed deduction under section 80p2 and may I read this page number? The assessee file is return of income such and such, the cooperative societies, ATP, its total income to the tune of such and such. As to the claim of the state, the assessee has stated that it is neither a cooperative society nor a bank under the Banking Regulations Act 1949. Rather, they are a land mortgage bank, and they lend against the mortgage land. The year of the assessee also stated that in terms of section 50C CCI, the cooperative society credit, it is defined as a cooperative society, the primary object of which is to provide financial accommodations to its members, and includes a cooperative land mortgage bank against the year. Emphasis that as per section 2(5) of the NABARD Act, the assessee is a state land development bank, and as per the clause 3 of or the part 1 of the Banking Regulation 1949, nothing in the act shall apply to the cooperative and mortgage bank. Hence, the assessee is to treat it as cooperative society eligible to get deduction under section 80p. Now, not considering the above vis-a-vis the categories of the members of the assessee society, and there is a activity of transfer to the assessee society being the apex society of the State Agricultural Rural Development Society is a cooperative sector. It does not. It does a business of long-term lending.
Sir, CIT appeals followed that decision in Todgarh.
Todgarh, yes. Everybody followed.
Assessing officer also.
Yes.
And in this appeal,
yes,
they followed the order passed by the tribunal.
Yes.
For 2006-7.
Yes.
That order was also based on Todgarh. There is no other independent decision taken.
No.
And the tribunal at page 134 relies upon another decision of Patna, where the interest on PF amount of the employees.
That is not
That is not applicable. Yes.
Decision is very clear. Please come.
There are small 1 or 2 grounds more.
Oh, other grounds are there. What are the, please sit down. Where are your questions?
But his questions
Page
are
14, man.
Page 14, yes.
So question B will be this ground.
My lord. B and BCD same issue.
BCD same issue.
E and F.
E and F, what is this?
My lord, E relates to, there are 2 components. Interest on personal loans amounting to 21.98 lakh and house building loan to staff to the tune of 1.76 lakhs. So interest on house building loan to the staff, my lord, I have no case. It is not attributable to the business, but this interest on personal loan, my lord, AO himself has observed in the assessment order that apart from certain entities, banks, etc., I am also having members, individual members, to whom I am lending money. So if in the process of lending money, I am earning interest from them, that qualifies for ATP deductions.
Let us see the AO's finding.
My lord, firstly, at page number 49, para I. I have the 4 classes of members: state government, 24 primary, agriculture
what
and
does ARDP means?
Agricultural and rural development banks.
Then 450 cooperative societies, and class D, individuals above 18 years of age through branches.
And at page 53, he is dealing with the issue, third para.
No, where does he deal with the personal loan to individual members?
Third para at page 53.
Yes.
On verification of receipts for the year, it transpires that an amount of 21.98 lakhs has been shown as interest on personal loan and an amount of has been shown as house building loan to its employees. Neither of these interest income is eligible. Personal loan, money absolutely is cryptic, and ITAT is also very cryptic at page 134.
No, CIT appeals.
CIT appeal to entirely he is reproducing that Bangalore bench. Two lines is.
Then tribunal.
Tribunal, my lord, at page 134. Last para, my lord. Fifth line. Here also absolutely cryptic.
Personal loans are given to one category of members.
That was stated in the statement of facts before CIT appeal. My statement of facts before CIT appeal is at page 59. And this relevant averment is at page 61.
61 para 7.
Para 7, my lord. In last remaining ground, my lord.
Then the next is commission, miscellaneous income, sundry income.
Commission and miscellaneous income, my lord, I have no case. Because commission, I was taking a policy while giving loan, I was that commission.
So question F.
Sundry income, I have a case, but I am leaving it a small amount.
You'll be stretching it too far.
I am leaving it.
Attributable to that. And the deduction is false. Or please come.
Ground F may be taken as not pressed, madam.
Ground F. Or we will not refer to that book. Or we will refer and say not pressed. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961. Within bracket, the act is directed against the order dated 3rd September 2024, passed by the Income Tax Appellate Tribunal, C Bench, Kolkata. This appeal filed by the assessee. C Bench, Kolkata, within bracket tribunal in ITA number 1320/K1/2023 for the assessment year 2013-14. The assessee has raised the following substantial questions of law for consideration. Page 14 and 15, B, C, D, E, F. So you instead of B, C, D, you give 1, 2, 3. 1, 2, 3, 4, 5. We have heard the learned Subhash Agarwal learned so assisted by Rajshri so. I'm also Prithu Duria, senior staff respondent department. The learned advocate appearing for the appellant SSC on insufficient service that the substantial question of law number 5 as suggested above is not pressed. The said submission is placed on record and the substantial question of law 5 within bracket supra is rejected as not pressed. The assessee is a cooperative society carrying on the business of providing credit facilities to its members, earns profits and gain of business by providing long-term credit facilities to its members. The assessee being an apex cooperative society of the land mortgage banks in the state of West Bengal, funds are received from NABARD, all capitals, during the relevant financial year. And it is stated that the funds are received in 2 installments and the funds were in turn lent to the members in hundreds of installments. And as the assessee does the borrowing in a wholesale manner and lends on retail basis, there is always some floating fund. This floating fund has a cost, that is interest payable to NABARD, and the same is invested in short-term deposits, which yields income to the assessee and partly compensates the cost, namely the interest payable to NABARD. Therefore, the assessee's case was that these activities are integral to their business of lending, and the interest earned on the deposits is attributable to their lending business. Sir, please be seated. Further, the assessee contended that they receive repayments from borrowers in several installments, and they have to in turn repay to NABARD, which has to be done only twice a year. That is 31st of January and 31st of July of each year, as per the schedule fixed by NABARD. Therefore, the assessee has to accumulate the fund to pay the installment on the scheduled dates, and the interest income so derived, if not immediately required to be lent to the members, and or installments will be falling due after some period. The assessee cannot keep the said amount idle, and they deposit the amount in banks so as to earn interest, and such interest earned is attributable to the profits and gains of business of providing credit facility to its members. Further, the assessee contended that the society is not carrying on any separate business for earning such interest income, and the income so derived is the amount of profits and gains attributable to the activities of carrying in the business of banking or providing credit facilities to its members by a cooperative society, and the same is liable to be deducted from the gross total income under section 80 capital P of the Act. The assessing officer who completed the assessment under section 143 within bracket 3 of the Act by order dated 30/3/2016 did not accept the submissions made by the assessee by referring to the decision of the Honorable Supreme Court in Totagars, TOTAGARS, Cooperative Sales Society Limited versus ITO, 2010 188 taxman 282 within bracket SC. Agreed by such order. Apart from that, there was the assessee also contended that they are eligible for deduction of eligible for deduction under 80 section 80 capital P in respect of the interest on personal loans amounting to rupees 21,98,448 as well as interest on house building loan to staff to the tune of rupees 1,76,490. And this should be treated as income attributable to the banking business carried on by the assessee. The assessing officer held neither of these interest income is eligible for deduction under section 80 capital within bracket capital P within bracket numerical 2 within bracket small d, and therefore needs to be segregated. And the incomes are outside the line of business of the assessee and should be charged to tax under the head within inverted comma income from other source. Agreed by such order, the assessee preferred appeal before the learned tribunal. Before the Commission of Income Tax within bracket appeals -9 Kolkata within bracket CIT. With regard to the interest from interest earned by the assessee from banks other than Cooperative Bank, the assessee contended that the decision in Totagars Cooperative Sales Society is not applicable to the facts of the case and it is clearly distinguishable. With regard to interest on personal loan to members and interest on house building loan to staff, it was contended that the personal loans given were to the members of the society and the house building loan was given to the staff against mortgage of property, and some of them are also members of the society, and therefore deduction is permissible under section 80 capital P within bracket 1 within bracket 2 within bracket small a within bracket I of the Act. The CITA dismissed the appeal by order dated 1/11/2023 and on a perusal of the order we find that the CITA has extracted the findings recorded by the assessing officer and held that the assessing officer was justified in coming to the conclusion as arrived at by him in the assessment order dated 30/3/2016. Agreed by such order, the assessee preferred appeal before the learned tribunal. The learned tribunal also was persuaded to dismiss the appeal filed by the assessee by placing reliance on the decision of the Honorable Supreme Court in Totagar Cooperative Sales Society Limited. And after noting the decision, after noting the findings recorded by the assessing officer as well as the CITA, agreed with we are agreed with such finding, resulting in the dismissal of the appeal. Agreed by the same, the assessors preferred the present appeal. Substantial questions of law 1, 2, and 3 are interconnected and concerns as to whether the disallowance of deduction of interest income under section 80 capital P within bracket 2 within bracket small a within bracket I was justified, and while deciding the said issue, it has to be considered as to whether the decision in Totagar Cooperative Sales Society Limited would be applicable to the facts and circumstances of the case of the assessee. We need not labor much on this issue as we are guided by the decisions of the Karnataka High Court as well as the High Court of Telangana. Telangana and Andhra Pradesh, as well as a decision of this court. In Gutti Gen Dharak Credit Cooperative Society Limited versus Income Tax Officer Ward 2 within bracket 2, Mysore. 2015 60 taxman.com 215 within bracket Karnataka. Sir, page 6 of the compilation. One of the substantial questions of law framed for consideration was whether the tribunal in the said case was correct in law in holding that interest earned on the deposits in banks by the appellant cooperative society therein does not qualify for deduction under section 80 capital P within bracket 2 within bracket small a within bracket I of the Act on the facts and circumstances of the said case. The Honorable Division Bench took note of the statutory provision, namely section 80P2AI, and interpreted the word attributable inverted comma as mentioned in the said statutory provision. To explain the meaning of the word attributable, reliance was placed on the decision of the Honorable Supreme Court in Cambay Electric Supply Industrial Company Limited versus CIT 1978 113 ITR 84 within bracket SC, and it was held as follows. Please quote para 10 of the judgment at page 9 of para. In terms of the above decision, the expression attributable to inverted comma being a wider import, comma, the said expression is used by the legislature whenever they intended to gather receipts from sources other than the actual conduct of the business. The facts in the said case were more or less identical to the facts before us, as the interest income so derived or the capital, comma, if not immediately required to be lent to the members, comma, the society / assessee cannot keep the said amount idle. And if they deposit this amount in bank so as to earn interest, comma, the said interest income is attributable to the profits and gains of the business of providing credit facilities to its members only. Bearing in mind the meaning of the word attributable to, the court proceeded to consider as to the applicability of the judgment of the Honorable Supreme Court in Totagar Cooperative Sales Society. It was pointed out that the Honorable Supreme Court was dealing with a case where the assessee therein, comma, apart from providing credit facility to the members, comma, was also in the business of marketing of agricultural produce grown by its members. And the sale consideration received from marketing agricultural produce of its members was retained in many cases, and the retained amount which was payable to its members from whom produce was bought, comma, was invested in short-term deposit / security. The facts of the case of the assessee before us is entirely different, and as the amount which was deposited in the bank was not an amount due to the members, and it was not the liability of the society to the members, and therefore the interest earned from such deposits in the bank should be held to be eligible for deduction under section 80 capital P within bracket 2 within bracket A within bracket I of the Act. Yet again, in Tumkur Merchants Sauharda Credit Cooperative Limited versus Income Tax Officer, Ward 5, Tumkur, 2015-55 taxman.com 447 within bracket Karnataka, page 10 of the calculation. Identical issue was considered. And it was held that where cooperative society was engaged in the business of providing credit facilities to its members, comma, they deposited excess amount for short term in banks, comma, interest earned was entitled to be deducted under section 80 capital P of the Act. In Vaveru Cooperative Rural Bank Limited versus Chief Commissioner of Income Tax, 2017-88 taxman.com 728 within bracket Andhra Pradesh and Telangana. The Honorable Division Bench was considering a writ petition challenging an order of assessment passed under section 143 within bracket 3 of the Act, and the question arose was whether the denial, comma, by the assessing officer of the benefit of deduction under section 80 capital P within bracket 2 within bracket A to the petitioner's society therein is correct or not. The court considered the expression attributable to and held that since the statute does not use the expression derived from inverted comma, but uses the expression attributable to, inverted comma, accepted the contention of the petitioner therein that clause small a within bracket should receive a wider interpretation. It was pointed out that the decision of the Honorable Supreme Court in Totagar Cooperative Sales Society Limited can be relied upon by the revenue in cases where the amount payable to the members was retained for a short duration and invested by the society, as a consequence of which the amounts so retained would be a liability for the society. The facts of the case on hand is entirely different, as was the case in Vaveru Cooperative Rural Bank Limited. Furthermore, it was pointed out that in Totagar Cooperative Sale Society Limited, the said society was carrying on business activity other than marketing of agricultural produce, actually resulted in net loss to the society, and it appears that the assessee in Totagar was carrying on some of the activities listed in clause small a along with other activities. Further, it was held that the investment made by the petitioner society within bracket Vaveru, what is it? Vaveru, 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 had invested those amounts in fixed deposits in other cooperative societies or in the construction of godowns and warehouses, the department would have granted the benefit of deduction under clause small d or within bracket small e, as the case may be. Furthermore, the original source of investments made by the petitioner society in nationalized banks is admittedly the income of the petitioners derived from the activities listed in subclasses I, small I, to small Roman 7 of class A, and the character of such income may not be lost, especially when the statute uses the expression attributable to, inverted comma, and not any one of the expressions, namely derived from, inverted comma, or directly attributable to, inverted comma. In Principal Commission of Income Tax versus Kunja Samba Krishnan Udayan Samiti Limited, page 1 of the compilation. 2023 147 taxman.com 518 within bracket Calcutta. it was held that where the assessee / cooperative society earned interest income on surplus funds invested in deposits with banks and government securities, since neither the said amount of deposit was due to its members, nor it was a liability to its members, same would qualify for deduction under section 80 capital P within bracket 2 within bracket small a within bracket small I. Thus, the above decisions which have been referred to would squarely apply to the facts and circumstances of the assessee's case. And this will lead to the irresistible conclusion that the assessing officer, the CIT appeal, as well as the tribunal, erred in not granting the deduction as claimed by the assessee under section 80 capital P within bracket 2 within bracket small a within bracket small I of the Act, and also erred in following the decision in Totagar Cooperative Sales Society Limited, which is not applicable to the facts and circumstances of the assessee's case. Accordingly, substantial questions of law 1, 2, and 3 are answered in favor of the appellant relief. Substantial question of law number 4 has two components. One relating to interest on personal loans and the other interest on house building loan to staff. So far as the interest on house building loan to staff is concerned, we concur with the view taken by the assessing officer as affirmed by the CITA as well as the tribunal. Therefore, to that extent, the said question of law has to be answered against the appellant assessee. The other component which arises in substantial question of law number 4 is with regard to interest on personal loan given to the members. It is not in dispute that the assessee is registered under the provisions of the West Bengal Cooperative Societies Act, and it has got 4 categories of members. Class A membership members are state government, class all capitals. Class B CLASs are 24 primary agricultural rural development banks, class C are 450 cooperative societies, and class D are individuals above 18 years of age who are given loans through branches. If the as the assessee has earned interest on the personal loans extended to one class of members, namely members in class D, the said amount could be eligible for deduction under section 80 capital. Accordingly, this issue is answered in favor of the appellant. In the result, the appeal is allowed, and the substantial questions of law 1, 2, and 3 are answered in favor of the appellant assessee, and substantial question of law 4 is partly answered in favor of the assessee, namely with regard to interest on personal loans, and with regard to the other component, namely interest on house building loan to staff, the same is decided against the appellant assessee. Thank you.
Previous matter, previous.
The other appeal. There will be a short order. This is IT 8035 of 2025. This appeal has been filed by the assessee under section 260 capital A of the Income Tax Act 1961, challenging the order dated August 5, 2024, passed by the Income Tax Appellate Tribunal, A Bench, Kolkata, in ITA number 1434/KOL/2023 for the assessment year 2006-7. Identical,
No.
the
Milord, in this case, I have no case. Actually, what happened, this is the second round. And in the first round, the tribunal had restored the issue for a limited purpose of allowing the expenditure attributable to the interest income from fixed deposits. And at that time, Tudgar had come and the other decisions distinguishing Tudgar had not come. And SSC also accepted that decision. In the second round, now SSC is claiming after that was set aside, then fresh round of litigation ensued. It was only pertaining to the whether the
we'll do one thing. Let this be transcribed. We'll sign this order. Then we'll take up this matter.
But this matter, my copy has not been served. I'm not appearing. Your Lordship,
I will give a copy.
regularize my appointment.
All right.
I will
IT 8035 of 2025. We have heard Mr. Subhash Agarwal and an advocate appearing for the appellant assessee. Though the respondent department has been served, no counsel has been nominated. However, in respect of another appeal filed by the very same assessee, Mr. Prithu Dorial and senior standing counsel appeared in the matter, and therefore we have directed him to accept notice for the respondent department in this appeal, and his appearance be regularized with the department and his fee bills be honored. Let copy of the appeal papers be served on the learned standing counsel for the respondent within 2 days from date. List next week.
Great.
Lord, this issue was perennial bone of contention in West Bengal. And by this speaking and threadbare analysis, I think the issue will get a quietus. Because after Tudgar, lot of confusion was there. Still, I had handled many cases in IT-80. So,
but another matter I decided in Madras High Court, I don't remember, that was also a cooperative society. Like your case, they had lost right through. Assessing officer, CIT appeal tribunal, we allowed the appeal.
Grateful.
Item number 8.
Milord, I beg to appear, Milord, for the respondent, Milord. This matter has been heard partially, Milord, on the last Saturday, Milord. This matter relates to a show cause issued against a self-assessed bill, against which duty was paid, but the cess part, this is the case of consignment of mica product, Milord. So the cess part, which is very minimum, 1,87,000 something, Milord, that they did not pay. On that, show cause has been issued within time. It was adjudicated against them within time, but they have not been able to convince over the learned tribunal on the basis that their allegation was only with respect to the relevant date and whether the show cause was issued within time of 1 year, 6 months or not.
Sorry for interruption. The tribunal allowed the appeal saying that in the show cause notice, there was no demand for interest. How do you go beyond the show cause notice?
Yes, on the interest part. No, that part we have not challenged. This is SSC's appeal, Milord. We are not before Milord.
Oh, then why did you start at first? SSC's counsel is here.
Okay, Milord.
Yes,
my lord, I have exported mica products in the year 2014. And it was self-assessed, all the shipping bills. About 20 shipping bills were there. The proper officer, after having been fully satisfied, he has allowed cement and late export order was passed. After about 11 months, the department issued the demand notice saying that you have not paid the cess. That is at page 26, my lord. Simply, they have issued this demand notice saying that it is under section 28. You have to give this cess. Thereafter, we have gone to appeal, and appeal commissioner said no, order was passed in favor of them, and interest was also imposed by the adjudicating officer. We had been to tribunal. Tribunal said since the interest is not mentioned in the demand, so it should go.
No, they are not.
So far as cess is concerned, my lord, the bill, shipping bill that has been assessed, that has attained finality. So in terms of section 129D, I have got the book, my lord. (192). It says, may I read, my lord? The principal commissioner of customs or commissioner of customs may of his own motion call for and examine the record of any proceeding in which an adjudicating authority subordinate to him has passed any decision or order. That order has been passed by the subordinate officer. So principal commissioner or commissioner he can review this matter and direct the junior officer or subordinate to him to file appeal under section 128. That has not been done here. And I have got the judgment also read by Supreme Court that if it is under section 28, 129 action section to be invoked. And of course, tribunal judgment is there, that is spark leather. That is also I am relied upon. Politically. The cess has been imposed under the Mica Cess Act.
But this appeal is pending before Supreme Court.
No.
No, you
Supreme
please.
Court has already passed the order.
No, you have given this.
I've got this.
So you
Thereafter, I
please see
find anything.
the Supreme Court bench comprising of Honorable so and so granted stay in civil appeal number so and so was filed by so and so was filed by the Commissioner of Navasheva against
para.
such final order reported in so and so.
Last para.
While granting stay, the Supreme Court passed the following order. We have heard learned ASG for the appellant and seen pending consideration of appeal, directions for seeking presence of the customs officers, development commissioner shall remain stayed.
My lord, last para. It was also held the same that the issue related.
No. This is the finding of the tribunal, sir. See, the actual citation is 2024 389 ELT A41. A41 means interim directions. So you find out whether the appeal has been disposed of.
I have to check, my lord. But the Park leather is there that I have already submitted.
Parker leather is a single member.
It is tribunal's order.
It's a single member bench. Of course, he is a very renowned member.
That is pending, I believe.
You have appeared before this member?
Which one?
This Parkar.
Parker letter.
You see the name of the member, judicial.
That is at Madras.
You have not appeared.
No, I am here, my lord. I appeared in tribunal also.
Is excellent. I have appeared before. At that time, it was called Customs Excise and Gold Control Appellate. There's a case of smuggling of gold.
Apart from this, my lord,
No, judicial. From the
apart from this, my lord, if I am allowed to say, this shipment was allowed against self-assessment under section 17 of the Customs Act. It says that if you find subsequently that it is not correct or proper, the department should reassess the goods, reassess the assessment, and they should also pass order. That is under section 17.4 and 17.5. If I can read out.
No, very recently we delivered one judgment on 17.4 and 5. You go through the judgment. You ask Manasi, she will give you. You find out whether this appeal has been disposed of in axiom cortege. We have heard so and so also. Learned counsel appearing for the appellant SSC place reliance on the decision of the tribunal in axiom cortege, CORDAGS Limited versus Commissioner 2023 4 syntax 120 within bracket tribunal - Bombay bracket close. As could be seen from the report, 2024 389 ELT A capital A 41 within bracket AC. An appeal was filed by the department against the order of the tribunal and an order of stay has been granted. The learned advocate appearing for the appellant SSC is directed to verify as to whether the appeal is still pending or it has been disposed of. Next.
Item number 9.
Right, please, Your Lordship, and I move for the responding matter.
Yes.
Well, this matter, my lord, is
Where is Madam Manasi?
Mr. Shiv Shankar Banerjee is here, my lord.
He's coming. Sorry, my lord.
Yes, my lord, he is appearing, my lord.
My lord, the short point which I tried to raise on the last date. Lordship has already decided that once the sugar shares has been paid by them, it should come in should take it. But Lordship, now in this matter,
you said that the date of export was subsequent.
Yes, and he has also paid, by which time it was already extinguished. The levy. Now, Lordship, if someone pays any money anywhere, he cannot come and take set off with me, my lord. Then, Lordship, I won't be able to survive. Then tomorrow.
And what happened to the Karnataka High Court decision?
Lordship, Karnataka High Court, till Karnataka High Court, everything was there when the sesh was valid.
No, appeal was filed. What happened to the appeal?
Appeal was withdrawn for the purpose of threshold limit. The appeal was referred to a...
you said Lok Adalat, yes.
Yes, Lordship. Mr. Vipin Nair and one honorable judge was there, and the department decided that this is... So, Lordship, and now all those judgments...
to you, on the date when they remitted the cess was no longer
there. He conducted the thing after cess. Now, Lordship, wherever someone makes some payment, he comes and takes a set of...
This ground which you are now urging or raising was not raised in the earlier matters.
Lordship, to be very candid before your Lordship, as an officer of the court, I will say yes. But as a lawyer of my client, I will say, Lordship, maybe not in a very clear terms, but it was always said that he is not entitled to. Maybe the reasoning is a pure question of law, that since it has been extinguished, so question of law I can
argue before your lordship. And lordship, on the last occasion, I have shown. If your lordship at least allow us by admitting the appeal that we will make, and then lordship can make a in an appeal, lordship will.
This issue is decided, my lord. Supreme Court has decided, High Courts have decided that if suppose duty is not payable, and I have paid the duty, and I paid that duty, taken send back credit, and I have paid on the final product, and the duty paid on the final product is either equal to or more than the send back credit, then I'm entitled to take send back credit of that. Innumerable judge decisions are there, my lord. I've got a compilation of the entire thing, and I have made a compilation.
And if you can give him a copy to Mr. Banerjee.
Yes, sir.
Compilation.
Yes, sir.
Sir, my lord, all the judgment where it was in force. This is the only.
No. It's on the principle.
Principle.
Lordship, principle has been decided by your lordship.
No. Forget about cess. It's on the principle whether credit is admissible or not. You go through these decisions.
I will.
Give notes.
Where that is the compilation. That also one copy can be given.
Yes, ma'am.
Brief notes of argument. Please take note. Brief notes of argument on behalf of the respondent assessee, as well as a compilation of case laws being filed, which has been taken on record. Copies of the same have been served on the learned advocate appearing for the appellant department. List the matter on so and so date. You go through and come.
Except 22nd and 28th of this month.
Yes.
Avadicha. 20 27 দিও না 2 তারিখ দাও 27 28টা নেই 29 দাও কিংবা I'm deeply.
Next.
Item number 10.
No, these are my appeals. Next two matters, my lord. Mr. Abratos Mujumdar was appearing in the.
It's appearing for the respondent, my lord. I'm paying not today only. Yes, sir. Oh, sorry.
He requested me to not to proceed with the matter today. My lord, kindly adjourn it for 2 weeks.
2 weeks. Yes. At the request of made on either side 2 weeks. Next.
Item number 12.
2 weeks time again.
Item 12.
Yes, ma'am. Please, your lordship. Lordship, kindly remember this matter where I paid the duty twice on the
And
sale
who
of
will appear for the department?
Mr. Banerjee is appearing, my lord. He has requested to take not today, my lord. There is some difficulty, my lord. That's the reason.
Tapan Banja is there, no?
Yes, I don't see him. That's
At least I can praise my judgment. Last occasion, I've referred one judgment.
You place it in his presence.
Yes.
We'll decide it then and there. We'll say not today.
Yes.
Next.
Item number 13.
My lord, it may be on Friday because.
I'm for the appellant, my lord.
Okay, then.
My lord, I beg to pray for adjournment, my lord, in 13 and 14, my lord. I'll come the next day.
You don't have the copies.
My lord, I'm appearing in 14.
13 I am appearing, my lord.
13 and 14.
But I'll
No, the respondent she
pray
requests.
for a not to be.
Yes.
When do you want it?
Not any day, my lord. Only for the day.
Next
Because I
week.
want to appear physically.
Next
Deeply
week.
attached.
At the request of the learned
Deeply.
advocate appearing for the respondent department.
Item number 14.
Next, my lord.
14 is also same, my lord.
14 also same.
13 and 14, my lord.
Item number 15.
My lord, item number 15 and 16, well, I'm led by Mr. Banerjee. If your lordship kindly
All right.
grant adjournment.
You give a date first week of September. We'll stop.
First week September.
Your Lordship, I crave leave to file an appeal without the certified copy.
Yes, leave grant.
Appellate side.
Sir, one more case is dismissed, sir. I had already submitted a written application for this issue. Sir, this way, it has become impossible, sir, to proceed with any case, sir. And the reason behind all these things is Ayan Bhattacharya, Advocate Ayan Bhattacharya. He's doing all these things. Sir, please help. I have to file some more cases in High Court. This way, no case will be given justice, sir. Please help me out, sir.
Yes, please call.
Appellate side, daily list, serial number 1.
Sir, one more request. Sir, if I will file the review of the case which has been dismissed, sir.
Advise you, madam. We can't advise you, or you take an advice of some advocate and then you do it. Please excuse us.
স্যার 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 আমি বলছি একটু আমি আপনার নির্দেশে আপনার দপ্তর আমাকে রিট পিটিশন করার জন্য বলেছিলেন
Yes, call.
Serial number 1.
Adjourn for the petition, Lordship. Lordship, this matter has been filed, Lordship, challenging the registration cancellation order passed by the respondent number 1, Lordship. And Lordship, for this, Lordship, if your Lordship kindly come to.
My lord, I am for the respondent number 2, my lord.
Yes.
If your Lordship kindly come to annexure P3 in the stay, Lordship, there was a delay, Lordship. There's a section 5 application, Lordship. I'm sorry, I should address that first. There's a delay of 25 days, Lordship, in filing.
But then cancellation of registration, you can apply for revocation.
Well, that has been done, and now he has delayed the matter. It should have been done within 3 weeks.
Lordship, may I submit?
Lordship will kindly see the order of the land.
What he says is, they didn't have an opportunity to reply to the show.
The
Lordship will kindly, if your Lordship kindly take the show cause notice annexure P3 at page 28.
28, yes.
Lordship, the date of issuance of show cause notice was 14th of August, Lordship. And the same date, 14th of August, has been granted for appeal. Lordship, in the last but second line, in the same show cause notice, Lordship.
On the same day suspended.
On the same day, Lordship, in between, if your Lordship will kindly find, you are hereby directed to appear before the undersigned on 14/8/2024. The date of issuance of the show cause notice and the date of appearance before the authority is the same date, 14th of August 2024. The date the respondent is issuing the show cause notice and he is directing me to appear on the same day without a few.
And the allegation is?
Well, the allegation is,
my allegation is
34, page 34. He is having multiple accounts. Allegation is very serious.
Lordship, in your.
All right, we'll do one thing.
In the order passed, Lordship, your Lordship.
Let him file as of now, your registration has been suspended or cancelled.
It has been cancelled, Lordship.
All right. So the order of cancellation at page 34, you treat this as a show cause notice. Within 15 days, you submit your reply. He will afford you an opportunity and pass a fresh.
My humble prayer was that,
Lordship, restore it now.
Since the show cause notice is bad,
You are
initiation is
willing
bad.
to accept this order, you accept. Otherwise, we dismiss your appeal. This intra-court appeal by the writ petitioner is directed against the order dated 25/3/2025 in WPA 28899 of 2024. In the said writ petition, the appellant had challenged an order of cancellation of registration granted to the appellant under the provisions of the Goods and Services Tax Act. As could be seen from the show cause notice dated 14/8/2024, the appellant was directed to appear before the authority on 14/8/2024 at 15:10 hours, and on the same date, the registration was suspended. Thus, it is evident that the appellant did not have adequate opportunity to put forth his submissions. In any event, now an order of cancellation having been passed, the following order will meet ends of justice. The appeal stands disposed of by directing the appellant to treat the order of cancellation of registration dated 6/9/2024 as a show cause notice and submit their reply within 15 days from the date of receipt of the server copy of this order. On receipt of the reply, the authority concerned shall afford an opportunity of personal hearing to the authorized representative of the appellant, consider the contentions that may be advanced, and pass fresh orders on merits in accordance with the law within 10 days from the date on which the personal hearing is concluded. It is made clear that the allegations made against the writ petitioner, made against the appellant writ petitioner, or the stand taken by the appellant before this court or before the learned writ court have not been gone into, and it is open to the appellant to raise all contentions before the authority. Next.
One may be condoned. Well, there is a delay.
Delay is condoned, sir.
Next. One personal hearing, Lordship.
Yes, personal hearing.
Yes.
Grateful.
Next.
Grateful, my lord.
Lordship, may I hand over the affidavit of service?
Affidavit of service taken on record. What is this, sir? Item number 2.
My lord, this is an intra-court appeal, but I have been given the brief only yesterday. Say,
who's for the appellant? So when do you want it? Tuesday.
my lord, Tuesdays.
Tuesday.
Wednesday, my lord. Kindly
Wednesday.
put it Wednesday.
At the request of the learned senior advocate appealing for the respondent department, Wednesday under the same caption. Next.
Grateful, my lord.
Serial number 3.
At serial number 3, Mr. Tanoy is appearing. Today is gone out of Calcutta, so he requested me to keep it on Monday.
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 At the request of the learned advocate for the respondent, Monday.
Great.
Serial number 4. This matter, I am for union appeal.
What is this?
This case is against originated from an appellate order passed rejecting my appeal for non-payment of the requisite 10% amount.
Pre-deposit.
My case was that I could not pay it because of stringent financial restraints, and a express case was made out in the writ petition, my lord. Even a certificate from the chartered accountants was attached, which showed that how my business has declined over.
Who's the contesting respondent?
The state, my lord.
Where is the state? Oh, yesterday Tanay was saying that he's held up somewhere.
Just before going, he had also requested him to pay not this week.
He is
Very well, he has gone to the Supreme.
and Mr. Sharaf wants to examine 39 witnesses. You are examining 39 witnesses. Yesterday, Tanay Chakraborty was saying, before authority, you are going to cross-examine 39 witnesses
39.
in some GST matter.
No, no, my lord.
Yes, yes. Yesterday he took.
My lord, in that matter, that Tanoy is not here. That matter only item number 3. My lord, in that matter, what is my only issue which is left, my lord, before your lordship is that I have requested for the toll movement data. My lord, there are 29 vehicles.
All right. This one also we'll have it on Monday.
Monday.
At the request of the learned advocate appearing for the state, Monday. At the request made on behalf of the advocate.
My lord, asking that the toll movement data be given because that is in the position of department to enable me to prove the movement of the toll. If something is in the department's position, they cannot act as my adversary that I will not deny you so that you are able.
What is the toll movement?
Toll movement, my lord, there is a RFID, my lord, this affixed on all the vehicles.
Yes.
And when they cross any toll, then they capture the data that this vehicle has crossed this toll bridge. So that I am able to prove that the vehicle has moved that much only. And the department is regularly demanding input tax credit reversal.
No, for that, you have got that FASTag.
FASTag, that is how, my lord.
FASTag, automatically it will be debited to your account. You take a printout of that and place
No,
it.
my lord.
Well, there are certain problems when a
My lord,
limitation.
the problem is that what I should be able to access the vehicle owner. 2 vehicles I could access, my lord, because the the data is not available with me. If that they have changed the RFID or those things, if they change, then I'm not able to access.
The state tax authority or central tax authority cannot have access to the toll data maintained by NHAI.
No, they have, my lord. In the e-way bill, it is integrated now.
Okay.
Because now my lord, there is a circular issued also that with the e-way bill system, they have integrated it to track the vehicle movement. So that, my lord, now what they are doing, that if suppose I claim that I have purchased the goods from Delhi, I give the e-way bill, I give the vehicle number, everything is there. But when they track it through the RFID, which has been now integrated with the portal, this e-way bill portal. So if they find that there is no vehicle movement, or suppose the vehicle movement, I am claiming that it has moved from Madras to Calcutta, whereas the vehicle at that on that particular date is moving from Madras to Delhi. So they are saying you reverse the credit. So what they are already utilizing that data, because now from 2019 onwards it has been
Now,
merged.
if it is integrated in this GST portal,
Yes,
you don't have access.
I don't have that access. Only they have the access.
But prima facie, have you produced some document to show that the vehicle has moved?
I have produced two movement data of two vehicles. Rest of the vehicle, I am requesting the authority that you please verify the toll movement data. Because I am not able to access that, so you have the access. They have the access, my lord. They are issuing so-called notice on the basis of that toll movement data only. That is their primary, my lord, the basis to deny me the credit.
Okay. Let us see.
Well, further, my lord, the RFID data is not a conclusive data, my lord, as because RFID, my lord, that payment, my lord, the toll payment, my lord, it is tagged to the vehicle number or the chassis number, or there is another, my lord. There are three ways to tag it up, my lord. Now the department, my lord, they are going through only the vehicle numbers, my lord. They search the vehicle number. Might be if the RFID data has been generated through the engine number, my lord, or chassis number, my lord. They'll not get it. My lord, it is, my lord. I have evidences, my lord. I have placed it before the circuit bench, my lord, where evidences are clearly, my lord, whereof they have searched through the engine number, the vehicle number, and I have the RFID data stating clearly that the engine of that vehicle, my lord, RFID data was generated through that, my lord.
But why you have to give chassis number or engine number?
Well, it depends
upon
upon
a registration number.
Well, it depends upon the driver, my lord. My lord, they do it on the highway, my lord. These are all truck drivers, my lord. They get it done through the agents, my lord,
No,
on the
which
highway.
is easier, registration number
My
or
lord, for
chassis
us, my lord, having a car, my lord, it is easier the registration number. But the driver or the agent, my lord, whoever does it,
Then
my lord,
there is some mischief, sir.
well, my lord, they cannot be, my lord, as because subsequently I am proving that the vehicle has moved down to the destination as it ought to have moved, my lord.
Let us see.
My lord.
Next.
Serial number 5.
My lord, 5 praying for, my lord.
Tuesday.
My lord. My lord.
Tuesday.
Grateful.
At the request made on behalf of the learned advocate for the respondent.
Grateful.
Serial number 6.
Your Lordship, I appear for the petitioner. This application is pertaining to an appeal which was dismissed on the ground that the appellant will be going before the first appellate authority to file an appeal. Your Lordships were pleased to grant 60 days time to file the appeal. However, due to a bona fide miscommunication, it was not filed within time. The matter was mentioned. As per your Lordship's direction, we have filed an application. So kindly.
Where is your CAN 3?
Yes, pardon, your Lordship.
CAN 3 is your application for extension.
Can
CAN 2 or CAN 3?
This is CAN 3, your Lordship.
Where is CAN 3? CAN 1, CAN 2, CAN 3. Yes.
CAN 3.
It's here. You want a further 30 days?
Further 30 days time.
This application CAN 3 of 2025. Slowly. This application has been filed to grant the appellant to extend the time period granted in the judgment and order dated 22/4/2025 in MAT 539 of 2025 by a further period of 30 days to enable the appellant to file the statutory appeal under Section 85 of the Finance Act 1994. The appeal and the connected applications were disposed of on 22/4/2025 by granting liberty to the appellant to file an appeal before the appellate authority within a period of 60 days from the date of receipt of the server copy of the order. And further direction was issued to the appellate authority to entertain the appeal without reference to limitation, subject to compliance of the pre-deposit condition, and the appellate authority was directed to afford opportunity of hearing to the appellant and dispose of the appeal on merits and in accordance with law. In this application, it has been stated that on account of inadvertence and bona fide miscommunication, the appeal could not be filed within the period of limitation, within the period stipulated by this court, and the appellant is ready and willing to file the appeal and prays for extension of time by a period of 30 days. We have heard the learned senior standing counsels appearing for the respondents on the above contentions. Considering the peculiar facts and circumstances of the case, the time limit stipulated in the judgment and order dated 22/4/2025 in MAT 539 of 2025 is extended by a further period of 30 days from date to enable the appellant to file the statutory appeal under Section 85 of the Finance Act 1994. If such appeal is filed, the appeal shall be entertained without reference to, it has been typed as referring, without reference to limitation, subject to compliance of the pre-deposit condition. It is typed as 100% condition. And the appellate authority shall afford an opportunity of hearing to the appellant or their authorized representative and dispose of the appeal on merits and in accordance with law. Application stands disposed of with the above direction.
Your Lordship, the affidavit of service may kept
Affidavit
on
of
record.
service kept on record.
Great.
Obliged, Your Lordship.
Yes, my lord, I beg to appear on behalf of the applicant hearing. My lord, this is the press contempt application order passed by your lordship on 6th March 2025. That is at page 27. But if your lordship kindly sees once.
Before that, my
Thereafter,
lord. Before that, my lord. What
please,
happened?
please, let me have the chance. Let me have the chance to continue. Thereafter, my lord, a bunch of my lord, SLP was preferred challenging this order. That is at page 57. And that has been dismissed by the Honorable Supreme Court. Thereafter, my lord, review application has been filed. That was also dismissed by your lordship. That is on 10 June 2025. That is at page 66. Now, my lord, we have filed the contempt application. We are before your lordship.
Now, my lord, I may be allowed, my lord, though I am not railway authority, my lord, different. That organization lordship was kind enough to raise question whether I am registered or not. So for that question is concerned, we have filed one application, review application that is pending. Because, my lord, innumerable application of our organization entertained by this court and division bench.
No, if you still defy the order.
No, my lord, I am not defying it.
Then?
And Honorable Court was kind enough, and even Apex Court was kind enough to endorse, my lord, the suggestion by this Honorable Court. Alternative route, even if there is the railway authority doing work on this. And we have no objection, my lord.
Already you serve on the state respondent and the Union of India.
And my lord, kindly matter which we have filed for recalling, my lord, so far the observation made by our organization may kindly be listed along with this matter.
That we will take it up separately. First, we
Deeply obliged.
The learned advocate appearing for the applicant is directed to serve the learned advocates who appeared for the state respondent as well as for the Union of India in the writ petition. List after 10 days.
My lord, I am grateful.
My lord, railway authority, my lord, exercising, my lord, their option on the basis of observation made by this Honorable Court and Supreme Court.
And you will accept notice?
Yes, my lord, certainly, my lord. We are ready and willing to do that.
Which respondent?
My lord, the Association for Protection of Democratic Rights, the separate matter was there. Lordship was kind enough to take up this matter. On that date, we have drawn attention of this Honorable Court.
Oh, your client is not a party in the contempt?
No, my lord, certainly
My
not.
lord.
Not standing on the way, my lord. The suggestion taken by the, we are accepting.
Yes.
Serial number 8.
Mr. Kundu, you could have appeared online.
My lord, I believe, my lord, your lordship, the echo is too much, my lord.
That is, if you change your audio system, that is enough.
Yes, my lord, your lordship is correct, my lord. And I'll not be very brief before your lordship, my lord. Because of time, my lord friend may have
The
to.
compilation desired by your lordship, I am appearing for Indian Oil Corporation. Kindly looks into your lordship's previous order.
Two things, action, there about.
Your colleague has.
My lord, two things, my lord. I have gone through the compilation which has been prepared by my learned friend. My lord, to be very honest, my lord, I am not satisfied with the documents which he had, my lord, annexed to the.
Then you file a
no,
complaint.
I have done what I have done is because all the papers are there for lordships, and therefore, my lord, instead of, my lord, multiplying the documents, I will place reliance on the documents. I will only place reliance on two things, my lord. The list of dates which he has prepared and the list of dates which we have prepared. We are lordships, my lord. Maybe everything is same. Two or three things which he chose not to, whether deliberately or inadvertently, not to record those things. Your lordship takes up my list of dates, and then your lordship, if your lordship wants, the addition. No, I'll give it to you. I'll give it to you.
No. Why we requested a convenience set was so that we can't, instead of rummaging through all the papers.
Absolutely.
What we can do is, sir, in fact, they have made a convenience set about how many pages is there?
Yes.
About 117 pages.
Yes.
Whatever documents, if you feel are been missed out,
Yes.
that alone you file a small set. We'll have this in the event. Still, you want to refer, we will go there.
No, only two things. I will be relying on all the documents which they have annexed.
Very good.
Excepting one or two documents which if your lordship feels that your lordship is required to go through those documents, I'll invite your lordship to go through the paper book only itself. I'll not go anything beyond the paper book which is already there on record. Your lordship will only take the dates, but if your lordship wants that a convenience set be prepared on the basis of my list of dates, then of course the entire bundle of documents will be very huge before your lordships.
I think
That's
the
the
matter
only.
should, let him please the matter on merits. I think
I think we can't complete it today.
No, I'll take some time. I will take some time. I'll be very
I have
candid
got
to
a
your lordships.
meeting at 3:30. Today
Okay.
is not possible.
Okay.
So when
Well,
do
in that even not may I make the summary brief for your lordships on Monday. Lordship kindly gives me a convenient time so that I can come and finish it up so that I don't want to linger the hearing of the because
instead of Monday, you can take Wednesday, Tuesday or Wednesday.
13th and 14th Wednesday.
Bolo.
Tuesday is all right, not 13th and 14th. Wednesday and Thursday, I'm some difficulty. I'm assisting Mr. Kundu. So Tuesday it can be done.
12th it can be had.
Yes.
Yes. All right.
In the event your lordship wants a convenience set to be read by the appellant, I can do so.
But that will be very voluminous. No, what we
I don't want to. That's the reason why I didn't want to
No, we will
multiply the number of
go by this set, and whatever documents you want to refer, we'll go to this.
Your lordship will only see one thing. In my list of dates, I have only stated that certain notes are there. If your lordship wants, the notes refer to some of the documents which is already there in the paper book.
That we will refer. So
That's the only thing.
you need not prepare any separate set.
No. That's what I'm saying.
Convenience set as directed has been prepared by the learned advocate appearing for the respondent oil corporation along with the list of dates and events. The learned senior advocate appearing for the appellants contended certain dates and events have been missed out, which he will place on the next hearing date, and certain documents.
We are also producing a list of dates.
Missed out, and list and a separate list of dates has been prepared by the learned advocate appearing for the appellant, which is also taken on record. Further, it is submitted that in the convenience set prepared by the learned advocate for the respondent oil corporation, a few documents have not been annexed, which will be referred to in the course of argument from the annexures to the stay application. This is the matter under the same caption on Tuesday.
Could I make this humble prayer to your lordship on Tuesday? Lordship will give me some question. I know it's fairly at the top.
No, only we will have fresh admissions, and
Well,
because
I will not stand in the way of admission of fresh matters, my lord.
you want, you can appear online also.
No, I'll I'll feel much more comfortable so that my learned friend can also go through what I may miss out from the. There'll be a difficulty in not coordinating with online and also my learned friend.
So if it's any inconvenience, senior counsel.
No, I shall approach my lord.
Published.